Picture a scenario where America's most widely owned rifle, the AR-15, was suddenly declared to fall outside the protections of the Second Amendment, making your lawful ownership of these firearms illegal. This isn't just a hypothetical situation. Multiple states have attempted exactly this through rifle prohibition laws, and numerous localities and counties have followed suit with similar restrictions. A significant challenge to these prohibitions has now officially reached the United States Supreme Court once again, and the justices are being asked to finally settle a fundamental question. Are these AR-15 prohibitions constitutional, or should they be invalidated nationwide once and for all? Before we dive deeper, if you're watching this content, it's clear you value the Second Amendment and your constitutional rights. Here's something important to consider. Even responsible, law-abiding firearm owners sometimes end up facing serious legal consequences because they make crucial mistakes without realizing these actions are problematic or illegal. To address this concern, I've created a free resource called the Legal Survival Guide designed to help you avoid these potential pitfalls. This straightforward PDF takes approximately 2 minutes to read and could potentially save you from years of incarceration. I developed this resource specifically to assist you at no charge. You can download it using the link provided below. It's designed to be stored on your phone or printed out for reference, and it includes a wallet-sized card with additional resources to help you navigate challenging situations. To be clear, this isn't intended as legal advice, and I'm not serving as your attorney. There's no attorney-client relationship here. However, I wanted to provide you with these free tools to help prevent you from ending up in unfortunate circumstances. If this interests you, simply click the link below and enter your email address to receive this free PDF. The case we're examining today is Viramontes versus Cook County, and the petitioners include individual citizens alongside organizations like the Second Amendment Foundation and Firearms Policy Coalition. They're challenging Cook County's ordinance that criminalizes the sale, transfer, or possession of what the law terms assault weapons, which essentially means AR-15s, AK-47s, and approximately 100 other rifle types specifically named in the ordinance, including various AR and AK platforms. This isn't merely a symbolic ordinance without teeth. Violations can result in firearm confiscation, substantial fines beginning at $5,000 and escalating from there, and even jail time for simply running afoul of this ordinance. This legal challenge attempts to leverage recent statements made by Justice Kavanaugh in connection with the denial of another rifle prohibition case that came before the court during the previous term. In that denial, Justice Kavanaugh indicated that the time would arrive soon when the Supreme Court would need to address this critical rifle prohibition issue and potentially magazine restriction cases as well. He suggested this could happen within the next term or two. The plaintiffs are now presenting this case as the appropriate vehicle to fulfill that promise, arguing the Supreme Court should take up this crucial review. The case began back in 2021 when this lawsuit was filed in federal district court in Chicago. The petitioners challenged the county's prohibition under both the Second and 14th Amendments. Then in 2024, while the case was still pending, Illinois enacted a statewide assault weapon prohibition known as the Protection of Illinois Communities Act, often abbreviated as PICA, which essentially duplicated Cook County's restrictions on AR-15s and similar rifles. Around that same period, the Seventh Circuit decided another case called Bevis versus Naperville, upholding Illinois' law by claiming that AR-15s were excessively militaristic in nature. Because they possessed these military characteristics, the court ruled they weren't protected arms. The court determined that firearms useful for military service could be prohibited by states or localities, and they upheld those restrictions based entirely on this military utility standard. The district court reviewing the Viramontes case concluded they were bound by that earlier Seventh Circuit precedent and ruled against the plaintiffs. The district court issued summary judgment favoring Cook County. In 2025, right after another petition was denied review by the Supreme Court, this case was pending before the Seventh Circuit. Around that time, the Seventh Circuit suddenly decided to affirm what the lower court had determined. They simply stated they were following their circuit precedent and would uphold the lower court's ruling. The decision relied heavily on that prior Bevis case, treating AR-15s as essentially civilian versions of M16s and therefore outside Second Amendment protection. This has now prompted the plaintiffs to petition for Supreme Court review once again, pushing the justices to finally take up a rifle prohibition case and strike down these types of restrictions in counties, states, and essentially nationwide. In their petition, the plaintiffs first argue that the circuit courts are divided and deeply confused about how to apply the Heller and Bruin decisions when addressing these rifle prohibitions. Some courts acknowledge that AR-15s are arms, but claim they can still be prohibited anyway. Others maintain that these rifles simply aren't arms at all and therefore lack protection. They uphold rifle prohibitions based on the assertion that these firearms don't qualify as arms. The petitioners maintain that the Supreme Court needs to clarify that all firearms, including semi-automatic rifles like AR-15s and AKs, are arms protected under the Constitution. Second, the petitioners present surveys, production numbers, and sales data demonstrating that tens of millions of AR-15s and other similar rifles are currently in circulation. These firearms are used for home defense, target shooting, hunting, and other lawful purposes. Therefore, they're in common use for lawful purposes and protected under the Second Amendment. They pose a fundamental question. If the Second Amendment doesn't protect the most widely owned and used rifle in the nation, what exactly does it protect? Third, they highlight that Cook County and the Seventh Circuit rely on the premise that AR-15s are military firearms with militaristic characteristics. But the Heller decision, they argue, never stated that firearms can be prohibited simply because they're useful for military service. Instead, the only historical limitation recognized by the Supreme Court applies to weapons that are both dangerous and unusual. AR-15s, by contrast, are common, popular, and overwhelmingly used for lawful purposes like self-defense, hunting, and target shooting. The useful military service analysis employed by the Seventh Circuit and other circuit courts was never part of Heller or the Bruin analysis and should be outright rejected and struck down by the Supreme Court. Fourth, the petitioners contend that under the Seventh Circuit's reasoning, lawmakers could prohibit every firearm except for specific handguns potentially mentioned in Heller. This would effectively neutralize the Second Amendment and leave it vulnerable to complete erosion. Essentially, during every legislative session in a state, lawmakers could progressively chip away at firearms rights, banning more firearms types as they move down the list of what they want to prohibit, potentially opening the door for Congress to do the same thing. They emphasize how the defiance following Bruin and the Supreme Court's inaction is creating this situation, and it will continue until the Supreme Court decides to finally intervene, as Kavanaugh indicated, and strike down these rifle prohibitions, magazine restrictions, and the outright defiance of what happened after Bruin. Finally, they argue this case presents a very clear scenario on final merits, making it the perfect type of case for the Supreme Court to take up. The firearms at issue are AR-15s, which they describe as America's rifle, and there's no factual dispute about how popular these rifles are. Multiple circuit courts have split on this rifle prohibition issue, including whether these AR-15s and similar semi-automatic rifles qualify as protected arms. Millions of citizens and Americans are affected by this, and Supreme Court intervention is significantly overdue, as recognized by Kavanaugh in the denial statement, saying that within the next term or two they would have to address this issue. At its core, this case asks the Supreme Court to finally address one of the main questions they've been called to answer for many years: whether these types of arms are protected under the Second Amendment. The petitioners state clearly that if the AR-15 isn't protected, then most firearms aren't protected, and the right to bear arms itself becomes essentially meaningless. This isn't just a question relevant for Cook County or the state of Illinois. It's a question that impacts every state and every American firearm owner who possesses these types of rifles. From New York to California, certain states have outright prohibited these firearms. But more and more states are adopting these rifle prohibitions. We've seen Washington, Oregon, Colorado, and others implement these types of restrictions, and it's only a matter of time before this spreads even further. It's finally time for the Supreme Court to stay true to their promise, step up, and address this issue. As we receive more information and this develops, I'll keep you updated. If you found this content valuable and want to support the channel, one of the best ways is to simply subscribe. You can also visit my website at armscollar.com, where you'll find the free legal guide I mentioned, along with channel merchandise and other offerings you can explore. As always, thank you so much for all of your support. And never forget this nation was built by armed scholars and will be maintained by armed scholars.